Hi, I'm Bill Hazlett and I'm a principal with Hunt & Hunt Lawyers and a chartered tax advisor. And today I and Andrew Sinclair, an associate of the firm and also a chartered tax advisor, will talk to you about estate planning, what you need to know.
Okay, so before Bill mentioned estate planning and succession planning, we wanted to give a bit of an explanation of the key terminology that's used in this area, because there is some confusion about a lot of the terms in estate planning. Estate planning refers to dealing with your assets when you die, whereas succession planning is broader. It contemplates dealing with shares you might own in companies, the family business, and control of family trusts. The next term is testate succession, and that's to be contrasted with intestacy. Testate succession is where someone dies with a will, whereas intestacy is where someone dies without a will. Where someone dies with a will, they go through this process that's known as probate. So they apply to the Supreme Court of Victoria for a grant of probate. Whereas in the case of intestacy, generally the person who has the greatest claim to the person who's died's assets will apply for what's known as letters of administration. Just to go into a little bit more detail on probate, probate is the process, as I mentioned before, where you go to the Supreme Court and get the power to administer the person's estate. What you do is you put together an affidavit, you attach the will. It's that document that is then lodged with the court. The court then grants you what is known as probate. That empowers you to deal with the person's assets, and you become the executor if you're granted probate. The next thing I wanted to talk about is the next term is deceased estate. So a deceased estate refers to all of the assets that the person held at the time of their death. All of those assets will form part of the person's deceased estate. Some other terminology that gets thrown around in the estate planning area is devises, bequests and gift. Devise is an archaic term that's used to refer to a gift of real property, whereas a bequest was any other gift of property that wasn't real property. These days, we generally just use the term gift. It's unnecessary to use the archaic terminology that was used before. The last point on terminology that I wanted to discuss was family provision, which used to be known as testator's family maintenance in Victoria. You may have heard of this, people may have referred to it as challenging someone's will. It's where someone who is an eligible person makes an application to the court saying that they haven't received enough from a person who has passed away's estate. Okay, so just wanted to discuss some of the things that we go through when a client comes into our office wanting to get their estate and succession planning done. The first thing we generally ask clients is, why have you come to see us today? What are your estate planning objectives? Because this, what they tell us when we ask that question will usually inform the estate plan that we want to put together for them. One of the first things we try and then do is establish what their estate assets are versus their non-estate assets. And shortly I'll come back and discuss the difference between estate and non-estate assets. Another consideration we'll make is whether a simple will is appropriate or whether a discretionary testamentary trust will or some other form of trust will, such as a special disability trust or a superannuation proceeds trust, might be useful in the client's circumstance. Another key point is client's understanding and capacity. Bill discussed capacity before, but I'd like to discuss a bit more about client understanding. It's critical when we have clients going through an estate planning process that those clients understand what it is they're actually achieving and what they're putting in place through their estate planning documents. As lawyers, we have a duty to ensure that our clients who come in to put in place wills know exactly what it is that those wills do. There are also very strict formalities for people who are putting in place wills. For example, they need to be witnessed by 2 independent adult witnesses that aren't beneficiaries. And we go as far as making sure that the people's wills are signed by the same pen for all 3 people in the room. There have actually been court cases where they've tested the ink from the pens to make sure that the witnesses and the person making the will were all present at the time that the will was actually made. Another point that we discuss with clients is digital estate planning and digital assets. For example, these days everyone has a Facebook, some people have Instagram, some people have iTunes. So we give clients advice about the best way of passing control of those things to the next generation and making sure that the photos that they've been taking for the last 10 or 15 years don't just get stuck in cyberspace, unable to be accessed by anyone. And the last thing we consider are whether there are any special circumstances of the will maker who's come in to see us to see whether some advanced estate planning strategies might be necessary. As I mentioned before, I wanted to discuss the distinction between estate assets and non-estate assets. Estate assets are the assets that are held personally by you at the time you die, and they're the assets that can be dealt with by your will. These are to be contrasted with non-estate assets which can't be dealt with under your will. I'll now give you some examples of each of these types of assets. So first I'll just explain that your spouse, for example, you and your spouse can own property as joint owners, or you can own property as tenants in common. Joint ownership is where you and your spouse both own the property, say your family home, together, and you both own 100% of that home, and the survivor of you will take that home on the death of the first of you. Tenants in common is where you and your wife both own your family home, but you each own 50% of that family home. In that case, that 50% of the family home can be dealt with under your will. But in the first case, because of the operation of survivorship, which is something that happens under law, the property will be unable to be dealt with under your will. Another thing that we wanted to discuss is superannuation. Superannuation, for example, falls outside of your estate. You can make a binding death benefit nomination that brings it within your estate. However, the default position is that superannuation is not an asset that can be dealt with under your will. Other things include life insurance policies. Life insurance policies depend on who the beneficiary is, who is named under the policy. So if you own a policy personally for yourself and you're the beneficiary, then yes, it will pass under your estate. But if you name your spouse, a child, the life insurance payment will be paid direct to that person and will not form part of your estate. Another thing to consider is assets held in companies. You might own the shares in those companies, but the assets held by those companies can't be dealt with under your will. The shares can obviously, but not the assets. The other non-estate asset I wanted to talk about was family trusts and assets in family trusts. These too can't be dealt with in your will. What's essential in these circumstances are the control of the trust. And as we discuss in our video on advanced estate planning, what you need to do here is do an exercise that deals with passing the control of those trusts. Advanced estate planning. So what are some of the circumstances where advanced estate planning strategies might be necessary? These circumstances can include clients where there's family law issues involved, where there's financial property settlements outstanding, It can be used where there's blended families and children from previous relationships. Advanced estate planning might also be needed for business owners, where someone has assets held in a trust, in a self-managed super fund, or in a partnership. Advanced estate planning may also be necessary where there's children with special needs, disabilities, or people in receipt of government benefits that you'd like to benefit under your will. They can also be used where there's beneficiaries who are likely to fight and don't get along. When we meet with clients who want to put in place advanced estate planning strategies, there are some key things we consider when we're meeting with them. The first thing we consider are the types of assets they have and the value of those assets. We also consider the tax and duty consequences and whether there's any ability to deal with those assets during their lifetime, even though death is not a CGT event. And there's a range of exemptions and concessions that are generally available for assets when a person has died. Another thing we consider is the client's circumstances and whether the client has particular needs for asset protection or whether any of the beneficiaries they intend on benefiting have needs for asset protection also. We consider whether there's any potential for family provision claims and our ability to minimise disputes. For example, assets can be given away to particular beneficiaries using a pick-for-pick method where names are drawn out of a hat and then the beneficiaries get to choose items in a sequence to minimise the ability for them to fight over who gets what. You can also choose carefully who you want to appoint as executors and trustees of your estate. Another thing that we consider is passing the control of non-estate assets, so your family trust, for example. When we're dealing with the control of trusts, we look at changing the appointor of the trust, changing the trustee of the trust potentially, appointing directors to act as directors of the trustee company if there's a trustee company, and also who the shares in the trustee company go to.
Advanced estate planning strategies. Among the strategies that we use in advanced estate planning are changing the ownership of assets, for example, changing the joint ownership of property to tenancy in common and vice versa. We can also transfer properties out of your name into superannuation funds or into trusts, because a transfer into a superannuation environment is a more tax beneficial environment. And a trust can also hold property and give you the benefits of income splitting and generation skipping. As well, we can look at gifting assets during your lifetime, and in some instances we will recommend that you not only gift a property but have a loan back to you so that you have some degree of control, but the equity arising in the future passes to the persons to whom you wish. We also utilise what are called discretionary testamentary trusts that I'll elaborate on later, and special disability trusts and superannuation proceeds trusts. We look at and use binding death benefit nominations in superannuation so that we can determine whether or not the assets are to go to a particular beneficiary or go into your estate. We also look at and examine reversionary pensions so that if you are in pension mode and die, your reversionary pension might be able to go to your spouse or partner, and we consider whether that's appropriate in your circumstances. We also consider rights to reside and life interests, so that if you wish somebody to reside in your property but that ultimately other beneficiaries are to have the benefit of that particular property after that person's death, then a right to reside or a life interest might be applicable. As well, we consider an option to purchase, so that if you wish to have someone benefit for a particular property and take that property at perhaps a discount, but you want the equity in your asset to go to other beneficiaries, then an option to purchase can be granted in your will. We look at insurance and consider whether your insurance policies should benefit your estate or benefit another person, because insurance policies and the proceeds of insurance won't form part of your estate unless the insurance policy is owned by the estate. We also look at and consider whether mutual wills or a contract to create mutual wills is appropriate in your circumstances, because you might want a situation where if you die, you want to make sure that your partner doesn't alter their will and change what the two of you have agreed to happen in your wills. We also look at whether any of your beneficiaries are non-resident beneficiaries, because if a gift is made to a non-resident beneficiary, then there are particular tax rules that apply, and your other beneficiaries may end up having to bear that tax liability. So we make sure that things are equalised by using particular provisions for non-resident beneficiaries. Now, I mentioned earlier discretionary testamentary trusts, and these are a major tool that we're using at the moment. And they have two major benefits. The first is asset protection. So all of your assets that you've worked hard for, you want to see go down the family line, and you would not like to see dissipated and go across to a person who's not one of your family or not one of your lineal descendants. So we provide particular provisions that if your beneficiary is subject to a family law claim, then immediately they step out of control of their trust and can take no further part in the control of that trust. This means that a family court can't make an order about those assets and require that those assets, like the BHP shares for example, be distributed to that other family law claimant. The other major tax advantage of a discretionary testamentary trust is because it's created in a will, then any amount that is distributed to a minor is taxed at normal marginal rates. So whereas an amount distributed to a minor through a trust created during a lifetime is taxed at the highest marginal rate once the distribution exceeds $416, a distribution through a testamentary trust of $20,542 can be tax-free, and even amounts distributed to a beneficiary over that sum can be taxed at normal marginal rates. So it's a very, very effective way of paying, for example, school fees for grandchildren and splitting income with people who would normally not be able to receive those distributions. And in a similar vein, we can create superannuation proceeds trusts, and if you have a beneficiary with a disability, then there are special disability trusts that can be created as well.
Thanks for taking the time to watch our video today. We hope you found it interesting and informative.
And if you have any questions at all about the information or about estate planning, don't hesitate to contact either us or a member of our estate planning team.